Right. Good afternoon, everyone, and welcome to our August segment of In the Boardroom with attorney Andy Phillips and Attolles Law, brought to you by the Wisconsin Counties Association. My name is Sarah Deidre Kasdorf. I'm the Director of Outreach and Member Engagement at the Wisconsin Counties Association, and I have the privilege of welcoming all of you today to this very informative and important webinar, given the fact that we are currently in the midst of quite a number of elections that are taking place across the state and in the country this year. I have to say I'm very excited about this topic, as I don't think in all of my years here, and Andy, correct me if I'm wrong, I don't recall us ever doing a presentation on electioneering political expression of county officials and employees. So I'm
Yeah, I don't
excited.
think we have, sir. I think this is a brand new topic. That's kind of fun.
Yeah, so I'm very excited to hear what you have to say today, Andy, and to share with everybody. Before I turn it over to Andy, I just want to make a few announcements. First, we will be recording this webinar, and the recording, along with Andy's PowerPoint presentation, will be posted on our website. Typically, we have it up within 24 hours or less after the conclusion of the webinar. So look for it on our website, wicounties.org. We now have a link right on the top right-hand page of our website called WCA Webinars. So once you're on our homepage, click on that, and that will get you right to the page where you'll be able to find this In the Boardroom, as well as previous editions of In the Boardroom as well. If you have any questions, and I know Andy likes this to be interactive, so if you have any questions throughout this webinar, please feel free to use the Q&A feature or the chat feature. Andy and I will both be monitoring those questions that come through through either the chat or the Q&A throughout the webinar, and we promise we will get to all of your questions, whether it is in the middle of the presentation or at the end. We'll make sure we get to anybody's questions or comments. So with that, I think that's all I have. Andy, I'm going to turn it over to you.
Wonderful. Thank you, Sarah. Great to be with everybody here on this fine Wednesday afternoon. I'm going to start with a concept about politics and county governments. We know that counties are nonpartisan, so we know that there is never going to be an R or a D issue that finds its way to the county board floor. I, of course, say that in jest because we've seen the infiltration of partisan politics in county government gradually become more and more prevalent over the course of the past, I would say, 6, 7 years or thereabouts. And I don't see it stopping anytime soon. And so I know a lot of you all have asked me over the past couple of years different questions related to what can we regulate, how do we regulate, what happens if, and so on. And so the purpose of this discussion today is to really level set and say, okay, here are the rules of the road, so to speak, as it relates to how we can, as counties, make sure that we maintain an air of decorum in our meetings, in our interactions, so that we can conduct the very important business that we need to conduct. And for at least me as a lawyer, I look at this in a couple of different lenses. First, we have this whole concept of electioneering, which we're going to talk about. And there are specific prohibitions about what you can or cannot do in terms of electioneering. But then we also have this pesky little thing called the First Amendment. Some of you may have heard of it. It guarantees the freedom of speech and expression to every individual citizen of the United States of America. And as state actors, as counties, we cannot infringe upon somebody's First Amendment rights. Well, the First Amendment has been around for a long time. And as you might imagine, there are plenty of cases and issues that have made their way up through the court system defining those First Amendment rights. And so I hope that you leave today's discussion with at least a foundational understanding of how the First Amendment might impact some of the things that we may want to consider as counties. As Sarah mentioned, feel free to hit chat or Q&A throughout this discussion to ask specific questions, and we'll get to it as best we can. So let's start with this concept of electioneering. Electioneering is defined in Wisconsin law. There's a statute on this, 12.03 sub 4. In simple terms, electioneering is defined as any activity which is intended to influence voting at an election. It could be a petition drive, it could be speech, it could be banners, it could be signs, it could be t-shirts, it could be any number of things, all right? So that's electioneering. Now, electioneering in and of itself is not prohibited. You can wear a t-shirt around in public that says vote for Donald Trump or vote for Kamala Harris. You can do that anytime you want. However, in Wisconsin law, You can't do that on election day. All right. So during polling hours, on public property, on election day, and within 100 feet of an entrance to a building containing a polling place, you can't do that electioneering activity. That's a violation of the law. Where I see counties get hung up on this from time to time, or I see individuals, people get hung up on this from time to time, is when we're talking about our county nursing homes. Oftentimes we have county nursing homes designated as a polling place because obviously we want to collect ballots from the residents in that nursing home. If that nursing home is designated as a polling place and we otherwise meet the conditions here on this slide, then somebody cannot engage in electioneering within 100 feet of that nursing home on election day. And so understand that when we're talking about the concept of electioneering, it's a specific definition within the Wisconsin statutes, and there are specific prohibitions that relate to an individual's activities that are electioneering under those certain conditions. So there are limitations. As I mentioned before, electioneering includes a very, very broad swath of conduct. Verbal campaigning, posting, distributing election-related material that includes any written material that describes or claims to describe voters' rights or responsibilities, for example, signs, banners, literature, T-shirts, and so on. As I mentioned before, the definition of polling place can be tricky at times. It's any building where polling is taking place, any public property, a municipal clerk's office where they receive absentee ballots. As I mentioned before, a nursing home, retirement home, or other special facility where special voting deputies are present at that home or facility to collect ballots. Anywhere where somebody's going to vote, you can't campaign, you can't electioneer. And so understand that under Wisconsin law, that is prohibited. All right. There are civil and criminal penalties if an individual engages in unlawful electioneering. So it pays to be smart about this type of conduct. Under Wisconsin statute 12.03, it can result in a $1,000 fine and up to 6 months in prison. And a violation of 12.03.5 can result in a $100 fine. All right. So there are penalties that attach to unlawful electioneering. I also want to mention this whole concept of misappropriation or misuse of county resources. This becomes important, and I hear this come up in the context more often in county elections. Why does this come up? Because you may have an incumbent in office that is running for reelection, a county board supervisor, county executive, constitutional officer. And oftentimes the distinction between constituent service and campaign material can be blurred. And there's no bright line definition as it relates to what is campaign material or what is essentially constituent service. So there's this 50-piece rule. All right. If an elected official is running for office, in other words, an incumbent is running for office, that individual cannot use public funds to pay the cost of materials or distribution for over 50 identical pieces of campaign material. It's the 50-piece rule. So we can get up to 50, but you can't go over 50. And so if we have an elected official who's running for re-election and they want to distribute out 500 pieces of material that is considered campaign material, we can't use public funds to pay for that campaign material. All right. Again, though, I want everybody to be cautious about this because there is no bright line definition of what is campaign material or what is merely constituent service. I'll give you an example. Let's say that we have a booklet that explains the county trail system. And that county trail system booklet is something that's available in the office of the clerk all times when the clerk's office is open. As a constituent service, could a county board member take 75 of those trail maps and distribute them out to constituents within that supervisor's district? Sure, absolutely. But if that happens around election time and that county board supervisor is running for re-election, takes those 75 trail maps and distributes them out to constituents, is that trail map considered campaign material or is it considered constituent service? What if we take it a step further and say, along with that particular trail map, that county board supervisor produces a pamphlet that says, hey, by the way, I've been your county board supervisor for the past 10 years, and here's everything that I've accomplished over those 10 years. What if that piece actually says, vote for me? Well, if it says vote for me, I think that then crosses the line over into campaign material. But up until that point, I think there's a question as to whether it's campaign material or not. So what I will tell you is that I think all elected officials that are running for reelection need to be aware of this 50 piece rule and ought to familiarize themselves with the campaign implications and the election implications as it relates to that 50 piece rule. Ultimately, this doesn't really impact the county. It doesn't impact the county because the county is not responsible to ensure compliance with this particular provision, but it does impact the incumbent. It does impact the candidate. And we know that in today's election environment, there's a lot of contention. I've seen it all over the place. So even in the most local of elections over the most innocuous issue, we see a lot of contention. And so I think there will be others that are looking at an opportunity to trip an elected official up over this 50 piece rule and file an official complaint with the Elections Commission about campaign conduct. So again, I think we need to be very careful and aware of this. Aside from the 50 piece rule, there's also a prohibition on accepting campaign contributions during established hours of employment or when engaged during your official duties. That seems pretty commonsensical, but sometimes sense isn't always so common. So again, familiarize yourself with these campaign rules to avoid getting entangled into an allegation that you're somehow violating campaign rules and regulations. All right, we have a couple of questions here. Let me see if we can post this. Kim up in Marathon County, wearing a t-shirt or hat to a polling place is not considered electioneering. Voters can do it, poll workers cannot. Kim, that's right. But again, I would just be cautious on that because I think it depends on what the t-shirt or shirt or hat says. Are we advocating a particular position? It's the same thing with signs and banners and things like that. And so again, I prefer not to get involved in even a debate about that. So I prefer not to do it. There are people that toe that line, so to speak. And so I'm not going to suggest that every single t-shirt or hat containing a political message or something that could be construed as a political message is going to result in a violation of the electioneering prohibitions. But I think that we need to be aware of those prohibitions to make sure that we don't cross that line. All right, Lori asked, does this include during special voting deputy visits to nursing homes not on election day? I think that depends on whether that particular nursing home is considered a polling place. In other words, has it been designated as a place to receive those ballots? I'm not sure, Lori, exactly what we consider the collection of those ballots to be, if it means that we're collecting them at the polling place, the designated polling place, or if it is merely an effort to collect those ballots in a lawful way, collect those ballots for deposit with the municipal clerk. So I think it would depend on those circumstances. Um, let's see here. We've got another message. Kim indicates again, we advise our municipal clerks that it's less disruptive to the polling place to make an issue of a t-shirt than to just let the voter come in, vote, and leave. I totally agree, Kim, because ultimately, as counties and even as municipalities, it's not as though we're on the hook if somebody wears some sort of t-shirt or hat or something to the polling place and starts electioneering. That's on them. They're the ones who are potentially violating the statute. Our interest is to avoid disorderly conduct. I know this came up in certain counties very recently as it relates to some very contentious recall votes that occurred. And I know that there was law enforcement intervention. So from our perspective as counties, we just want to make sure that our sheriff's office is aware of this issue and that we will do everything that we can if we anticipate problems to try to avoid those problems, have a presence at the polling place to try to cut down on the commotion, so to speak, that happens on election day. And I think it's always a good idea to try to be safe rather than sorry as it relates to creating a non-confrontational and a non-confrontational polling place in an area where people can feel comfortable voting. What if Brandon asked, would electioneering only take place during the day of voting? Yes, that's one of the conditions on prohibitions surrounding electioneering is that it's prohibited if it takes place during the day of voting. Now, what I will tell you is that electioneering definitionally, if we go back to the definition of electioneering, you will see that electioneering is defined as trying to influence voting at an election. You can influence voting in an election up to the day of the voting. Once that day of voting happens, if you meet those four conditions contained in statute, you cannot engage in that type of electioneering activity. All right, so we've talked about electioneering. And that is honestly relatively straightforward. And I'm hoping against hope that we don't run into a lot of electioneering problems at this November election. That said, I'm sure there will be pockets of disturbance around the state that we have to deal with. But to me, the more important question is what can we do, if anything, to regulate political expression? And what do I mean by that? Here's what I mean is that as counties, we're nonpartisan. And we want to encourage the spirit of debate, honest debate. We want to encourage the exchange of ideas. We have no interest in clamping down on people that want to engage in protected speech. That said, there is a point, whether it be during meetings or in the workplace or otherwise, where somehow that protected speech or perceived protected speech becomes a disruption to the orderly operation or business of county government. And so we want to avoid that disruption. So, where do we draw the lines between protected speech that we want to encourage and disruptive speech that we want to try to avoid so that we as a county can conduct our board meetings, our committee meetings, or the operations of county government in an orderly fashion? So, I want to talk about that briefly. All right. So let's start with this whole concept of county employees and officials that are attending board or committee meetings. All right. I want to start with the proposition that just because you're a county official or a county employee does not mean that you check your First Amendment rights at the door. County official and employees have First Amendment rights. All right. They can engage in political activities and have political opinions as long as those types of opinions and those types of activities are recognized as protected under the First Amendment. I want to tell you that some states have explicit laws that regulate political expression of county officials, the public, and employees in board meetings. Wisconsin does not have such a statute. And so we're left to our own regulations, our ordinances, or our board rules, the interpretation and application of those ordinances and board rules in the context of the First Amendment, and then implementation of those rules, which we'll talk about. All right. So I want to start with this proposition. Political expression at board or committee meetings, the open meetings, they're relatively unregulated unless the county has an ordinance or a board rule governing that conduct on the books. One of the takeaways I want you to have from today's discussion is that doing ad hoc regulation, case by case, meeting by meeting, situation by situation is problematic. It's problematic because we know that there is at some point going to be unequal application of whatever that rule is. And I think it leads to consternation on the part of the public in not knowing what the law of the land or the rules of the road are. If you don't have a board rule that speaks to limitations on what somebody can speak to in public comment, as soon as you try to impose a rule that is otherwise not published, not out there for public consumption, you're going to run into problems. The public is going to be upset. Okay. And again, just fundamental proposition, but it bears repeating. Any ordinance or board rule that we have on the books, we have to adhere to First Amendment standards there. All right. Both the United States Constitution and the Wisconsin Constitution recognize the right to freedom of speech and expression, and it prohibits us as counties, as state actors, from abridging on those guaranteed rights. All right. The United States Supreme Court, the Wisconsin Supreme Court, both consistently uphold the right of officials and candidates to express political views, opinions, and positions, even if those are unpopular positions, when engaged in the governmental process. So, what do we look at in terms of the limitations that we can place on this? Because I've talked about this whole concept of not wanting to create disruption, wanting to create an environment where we can conduct our affairs at a board or committee meeting or within the operations of county government in an orderly and efficient manner. We want to avoid disruptions. So how is it that we analyze our ability to adopt these rules under a First Amendment situation? Well, it depends on the forum. That means there are different rules for different places. All right. And this is how the Supreme Court has broken this down. Essentially, the Supreme Court has said there are three forums in a First Amendment analysis. And so whenever you have a First Amendment case, as a lawyer, we take a look at a First Amendment case, and the very first question that we ask, because we know the Supreme Court is going to ask this based upon precedent, is where is this speech occurring, and how do we characterize the where? In other words, what type of forum is this? The first category of forums is traditional public forums. Those forums are what you think of as the public park, the street, the sidewalk, the courthouse steps. These are areas that our Supreme Court has recognized as benefiting from the most protection under the First Amendment. In other words, we have the least amount of ability to regulate what happens within those areas. Because again, the Supreme Court has said that if you're going to restrict, that restriction has to be extremely narrowly tailored to serve a compelling governmental interest. Okay. So again, if we're dealing with a traditional public forum, our opportunity as a county to regulate speech and expression within that traditional public forum is going to be limited. The second category of forum is a limited or designated public forum. Okay. This is where we see the ability to regulate be greater than the traditional public forum, but not absolute. Okay. When we think of a limited or designated public forum, we're thinking of a county board meeting or committee meeting where we have an opportunity for public comment. All right. That public commenter has a First Amendment right of free speech and free expression, but it's not as open-ended as our traditional public forum, as though that person were sitting on the courthouse steps. No, there is a set of regulations that we can impose upon that public commenter, but we can only regulate on time, place, and manner of speech. What do I mean by that? Understand that as soon as we start regulating content of speech, what the speaker is talking about, we're going to have a concern under the First Amendment. And I'll get more into that in just a bit. But we can regulate time, place, and manner of speech. And then finally, we have non-public forums. These are the areas within the county that are not open to the public. All right. So we have our offices that are behind, for example, the clerk's front desk window. Those offices are not open to the public. And so those are considered non-public forums. All right. Schools, prisons, inside of government buildings, those are other examples of what courts have found to be non-public forums. In that instance, we can regulate speech so long as our regulation is reasonable and does not discriminate based upon viewpoint. In other words, we can regulate in the interest of maintaining an efficient and effective work environment, but we can't say something like that only Democrats can talk here, no Republicans, or vice versa, because at that point, we're regulating based upon viewpoint, not content, okay? So again, it's important to understand the three different levels of forums that we are dealing with in a First Amendment analysis, and our ability to regulate and the regulations that we can adopt or enact depend in large part upon what type of forum we are dealing with, all right? So let's talk first about meetings. Board meetings, committee meetings, and so on. I want to start with a very fundamental proposition as well, and that is we are not required by law to have public comment on any agenda at any meeting. There is no Wisconsin statute that requires us to do that. That said, I realize that the overwhelming majority of counties do have public comment on the agenda. All right, so public comment is there as an opportunity for the board or committee to get input from the public on a topic of interest to that member of the public. All right. So when we're dealing with public comment, conduct and expression at a meeting, or for that matter, if we're dealing with somebody's attendance at a meeting, all right, they might want to have a sign or a t-shirt or a banner. We can put reasonable restrictions on the commenter, reasonable restrictions on the attendees of that meeting, as long as they are based on time, place, and manner of speech and are content or viewpoint neutral, all right? Content-based restrictions on free speech are subject to strict scrutiny. What do I mean by that? Strict scrutiny is a legal term. And so when a judge gets a case like this and says, what is the level of scrutiny that I apply to this case? Strict scrutiny means that I'm going to take a hard look at the regulation to make sure that it meets all of the qualifications based upon the situation of it being a limited public forum. In other words, is the restriction reasonable? Is it based on time, place, and manner of speech? And is it viewpoint or content neutral? All right. And again, the judge is going to look at it and say, have you drafted this rule or this ordinance in a narrow way so that you are serving a compelling governmental interest? Again, there's no statutory constitutional right to participate in a meeting, but if your board rules provide for public comment, then it becomes a limited public forum. As I mentioned before, public comment and the opportunity for the public to provide input often presents challenges to the orderly transaction of business and maintenance of order at a county board or committee meeting. All right. So I want to talk about a few of the concepts that we see come through in case law as it relates to regulation within the limited public forum circumstance. We can enact viewpoint neutral place, time, and manner restrictions on speech during a board or committee meeting if there's a legitimate government interest. And here's the important point in my mind that comes out of the Perry case. Is the interest in an orderly meeting a legitimate government interest? The answer is yes. And so the United States Supreme Court has said that our maintenance of an efficient and effective board meeting atmosphere is a legitimate government interest, which gives rise to the right to enact reasonable viewpoint neutral regulations on that speech or expression. The Steinberg case came out in 2008. In that case, again, I think there's some good commentary within that case that helps us. Imposing restrictions to preserve civility and decorum are necessary to further the board's purpose of conducting public business. In that circumstance, in that case, the rule that was being challenged was a rule requiring a public commenter's speech or comments to be germane to an item on the agenda before, in this circumstance, the Planning Commission. The court, the Fourth Circuit Court of Appeals, said that that is a reasonable rule narrowly tailored to achieve a legitimate government purpose. All right. So again, when we're talking about building out our board rules or our ordinances that relate to restrictions on a public commenter or a meeting attendee's expression or speech, we can certainly say that whatever that expression is has to be germane to the agenda. I want to just deviate a moment as well, because I just said something that triggered something in my mind. I said when we're going to regulate the speech or expression of a meeting attendee or a public commenter, we know that a meeting attendee does not have the right to speak whenever he or she feel necessary. That right doesn't exist. Okay, so we can restrict somebody's ability to speak during a meeting if they're not at the lectern for public comment. But what about somebody wearing a t-shirt, having a banner, having a sign? Do we have the ability to regulate that? Yes, we do. We have the ability to regulate, again, so long as the restriction or the regulation is narrowly tailored to reasonably provide further civility or decorum or create the environment for the board meeting, which is a legitimate governmental interest. And so again, we have to take a look at the circumstances and say, is the prohibition of this t-shirt that has, for example, profanity on it, would that be a legitimate government interest? Yes, it would. Okay. But that's just an example of what, when we're dealing with signs, t-shirts, and banners, it may be a little more difficult to apply these rules than it is during public comment. But when it relates to public comment, we know, based on what the Fourth Circuit is telling us in the Steinberg case, that having a rule on the books that all comments have to be germane to an item that's on the agenda is okay. Now, I will tell you that there are some counties out there that vehemently disagree with the notion that we should have a rule on the books limiting public comment to items that are germane to the agenda. I've had conversations with a few of these counties. And I think that the theory is we want to know what's important to our citizens. We, as elected officials, ought to listen to our citizens, and they have a right to tell us what's on their mind. It raises questions in my mind and concerns, maybe not under the First Amendment, although the concerns still are there, but under the open meetings law, because it's awfully tough as county board members or committee members to simply stay quiet if somebody is raising an issue that you have particular knowledge about or a particular position on. And so as soon as you start engaging in back and forth debate, and that back and forth debate with the commenter turns into broader discussion with the committee or the county board, we may run into a problem under the open meetings law because that discussion is not on the noticed agenda. And so be very careful about how much we let people say during public comment. And if we are going to allow what I call the free-for-all, where the public can come up and talk about anything they want to talk about, we ought to make sure that all of our board and committee members are aware that we do not have any sort of right or opportunity to respond to those questions because of those open meetings law concerns. And before we get too far down this rabbit hole with the open meetings law, I'm aware of the exception in the open meetings law on answering questions from a public commenter, but I just see, and I think many corporation counsel agree with me, I just see concerns on the open meetings law if we start going down that path of allowing public comment and debate surrounding public comment. All right. What about obscene or disruptive speech? We talked about the rule as it relates to public comment and germane to the agenda, but what about obscene or disruptive speech as well? What about somebody who is wearing something that is obscene or profane? They're wearing a t-shirt that's obscene or profane, and they're just sitting in the audience. They're not even providing public comment. What can we do about that? All right. Well, first off, as a proposition, if speakers during public comment are being disruptive or threatening, they can be silenced. All right. Now, again, let's go back to that proposition that I started with, and that is ad hoc, case by case, situation by situation determinations about what is being disruptive or threatening, or the fact that somebody can't be disruptive or threatening. That's a problem. So I'd much rather have a board rule on the books. And I will tell you that over the course of the years, courts have had struggles trying to deal with what is disruptive or what is threatening. So it's not entirely clear as to what is going to be considered obscene or disruptive. I think it was the very famous United States Supreme Court case that said, I can't tell you what pornography is, but I know it when I see it. And it's awfully difficult to define obscenity, disruption, and things of that nature. So just be wary of that, okay? If you don't have a rule against the use of profanity, can you prohibit it? It's a bit of a rhetorical question. And what happens if even you have a rule prohibiting profanity, but you have a member of your board or a member of your committee that insists upon using profanity when they're debating a particular topic that's on the agenda? I'll tell you what's good for the goose is good for the gander. And so whatever rule we have on the books ought to be applied uniformly to members of the public and members of our board and our committees. All right. An unpopular or polarizing political stance in and of itself is not obscene or disruptive per se. So we have to be very careful about how we regulate that type of speech. Just because it's unpopular doesn't mean that it's going to be disruptive or threatening. In fact, if you look at our court cases over the years, it's the unpopular speech that is granted the most protection under the First Amendment. Okay. So we have to be very careful about how we regulate speech that is going to be considered unpopular. We want to err on the side of broad content neutral prohibitions. All right. So if we just say no speech dealing with such topic, we know that it's content neutral and not viewpoint discriminatory. If we can stick to that, then we're going to be okay. The reason and the primary way that I see that is working for us is a rule on the books that says any of your comments have to be germane to an item that's on the agenda, relevant to the agenda, relevant to the business that's currently before the board or the committee. We know that that regulation has been upheld by courts, and that allows us to regulate. If a speaker goes off topic, we can silence that speaker. Again, I'm not saying that it's a bad idea if you want to open up public comment to people in the public to come up and say whatever they want. I'm not saying that's a bad idea from a policy perspective, but just understand there are particular legal issues that arise as a result of that type of open-ended microphone that we are granting the citizenry. Again, let's go back to signs, t-shirts, and banners that are at board meetings. As you may have gathered from my discussion thus far and my struggles in trying to adequately explain how the First Amendment applies in these circumstances, it's a complicated issue. I will tell you that in what I do and what Attolles, our firm, does, we work a lot with school districts, and this is a big issue as it relates to what students and teachers do every day. Can we regulate what a student wears in terms of the t-shirt that has a political message? Can we regulate what our teachers wear as t-shirts or a flag in their particular office or their particular classroom? Same with counties. When we're at board meetings and we have people in the public showing up with signs, banners, and t-shirts, can we regulate what it is that they wear? Again, it's a complicated issue. Content neutral restrictions, time, place, and manner restrictions. Board rule establishing parameters is helpful. But again, this comes down to trying to apply terms that are by their very nature a bit ambiguous. What is disruptive? What is going to be considered profane? What is obscene? Is that really in the eye of the beholder, or do we have some sort of objective measurement that we can apply to that circumstance to say that by any measure, this particular t-shirt, this particular banner is going to be considered obscene? So I would really, really encourage you to work with Corporation Counsel on crafting your rules so that you don't have room for a lot of interpretation. Because if you got room for interpretation, you're inviting disagreement with members of the public. Here's an example of a rule that has been upheld by a court. This is out of the Ninth Circuit, and so it's out on the West Coast. According to this rule, which was a city council rule, it's unlawful for any person in the audience of a council meeting to do any of the following. One, engage in disorderly, disruptive, disturbing, delaying, or boisterous conduct, such as, but not limited to, hand clapping, stomping of feet, whistling, making noise, use of profane language or obscene gestures, yelling, or similar demonstrations, which conduct substantially interrupts, delays, or disturbs the peace and good order of the proceedings of the council. All right. I'm going to tell you the same thing that I tell all of you when we talk about ethics ordinances, is that it sounds really good and we put it on paper and say that rule makes sense. But then when you start digging into it, you're going to find an awful lot of ambiguity in the terminology within these rules. For example, what is disorderly, disruptive, disturbing, delaying, or boisterous conduct? Do we have a uniform definition of that type of conduct? Well, we have a list after that. And so we know hand clapping, stomping of feet, and so on is going to be considered disorderly, disruptive, disturbing, delaying, or boisterous. But does that list encompass the universe of conduct that is going to be considered disorderly? Probably not. No. And on top of that, we have the qualifier at the end. It says which conduct substantially interrupts, delays, or disturbs the peace and good order and proceedings of the council. All right. What is substantially interrupts? Is a 10-second interruption okay, but a 10-minute one not okay? And so you can see here the struggles that we have in both crafting this rule and then applying it to specific circumstances. And so even though this is a rule that a court endorsed, and I happen to think that this rule is as good as any that I've seen as it relates to defining what's going to be prohibited at a county board or committee meeting, there are still holes and there are still challenges because then we have to apply this rule. So again, it's a minefield. Work with your corporation counsel extensively when you're dealing with these issues. All right. And as I said before, what's good for the goose is good for the gander. Rules surrounding decorum, debate, and conduct at meetings are designed to provide for the orderly conduct of governmental business that applies to the public, and it applies in equal force to members of the board or committee. Conduct, speech, expressions may cause disruption if they're engaged in by the public, and they ought to be prohibited, but it also applies to members of the governmental body, all right? And I want to veer from the legal issues just a moment and talk about perception, all right? I think all of us as county officials want to be perceived as doing a good job for the citizens of our county. Absolutely. How does it look if we engage in conduct that would be considered to be lacking decorum, if we use profanity, if we use obscenities during board or committee meetings? That's not a good look when it comes to the citizens of our county having faith in the operations and governance of our county. And so we want to avoid all of that, all right? So I talked about rules of decorum as it relates to public commenters, rules of decorum as it relates to attendees at a meeting. We ought to think about board rules that speak to concepts of decorum that we place right in our board rules so that all members of the board understand the rules as it relates to their participation in the meeting, and that the public understands are the expectations to be an elected official within county government. I think that's a good idea. I will tell you that Robert's Rules has rules of decorum. Those are very general, very broad. I would like to see personally more counties take up the whole conduct and decorum issue in the context of their own board rules. I asked the question at the end of this slide. What about situations where a board member steps away from his or her seat and offers public comment? I've seen this happen from time to time. Well, the rules that apply to all other public commenters apply to that board member when that board member takes off his or her county board supervisor hat and steps up to the podium to give public comment. And so we ought to apply the rules that apply to every other public commenter to that particular board member. Now, personally, I do not like the fact that a county board member can simply give up his or her seat, take off that supervisor hat, and step up for public comment. I would much rather have a process where whatever it is that that supervisor wants to say can be said in the course of the meeting, because then all of the board rules that we have in place to ensure decorum during the board meeting are going to apply to that supervisor. But I know some counties lack that type of board rule, and so they allow supervisors to get up during public comment. I just want to caution that what is good for the goose is good for the gander, and so we ought to apply those rules evenly and uniformly. All right, I want to talk briefly about campaign and election-related issues for county employees, because that's different than the issues that relate to regulation of meetings, whether it be the meeting attendees or the elected officials that are participating in those meetings. As I mentioned before, when we talk about what is the ability of a county to regulate speech, we first focus on what type of forum it is. Remember that public comment during a county board meeting and attendance at a county board meeting, those are considered limited public forums. When we're talking about a county office that is not open to the public, remember we have a heightened opportunity to regulate that speech or expression, all right? Because those are non-public forums, okay? We don't invite the public in to offer opinions or otherwise engage in expression in those areas. Those are the areas where we're doing the very important business of county government, okay? So again, all that we have to do is, the only lens that a court would look through to determine whether our regulation is valid is whether the regulation bears a rational relationship to the legitimate governmental interest, which is to provide a workplace that is efficient, effective, and free from disturbance. All right. So generally, subject to local policies, ordinances, and rules, a work-related activity should remain separate from personal or political activity. Okay, we want to make that clear. Campaigning is not work-related activity. Okay, so we cannot campaign on public property in non-public areas, and we can have a rule in place that prohibits that type of campaigning. County employees should not use county facilities for campaigning. And when it comes to expression, as it relates to the freedoms that county employees have, we have do's and don'ts, all right? So as a county employee, you can apprise yourself of local rules, ordinances, and ethics policies. You can express support for a candidate or cause outside of work and on your personal time. You can put a bumper sticker on your car vehicle, regardless of where it's parked. You can post support or criticism of a candidate or party or particular issue on personal social media sites. You can on behalf of a candidate outside of work hours on your personal time. You can discuss an election in the workplace in a neutral manner. You can distribute neutral information about election while you're on the clock, and you can produce materials to disseminate that type of neutral information. So when I'm talking about all of the things that a county employee can do, let's take the flip side of that and say, well, what is it that a county can do in order to regulate? You can put together this list in county regulation, whether it be an employee handbook or ordinance or whatever, and say that here are the boundaries of what you can do as an employee. And here are the boundaries where we consider something to be outside of what you're allowed to do. So we can adopt reasonable regulations on employee conduct within the workplace Again, as long as it's neutral and as long as it's applied evenly and as long as it bears a rational relationship to the legitimate governmental interest of having a workplace free from disturbance and so on. What can't we do as county employees? Unless specifically allowed by local rule or ordinance or policy, we don't wear campaign buttons, logos, shirts, or hats to work. We don't display political signs on a county vehicle if a reasonable onlooker would identify that vehicle as a county vehicle and have the county somehow endorse whatever that political message is. We don't display support or criticism of a key political or campaign issue. We don't actively discuss campaign-related plans, issues, or objectives with candidates while we're at work. We don't endorse expressly or by inference any candidate or party on social media if our posting is part of our official job duties. All right. So all of this is to say that we want to exercise caution. We want to clearly delineate a distinction between professional life, the county workplace, and personal life. Every county employee is entitled to a personal life, okay? Understand that depending upon the particular position, the particular employment policy, or the particular employment position or job, it may be difficult for the public to differentiate between somebody's personal views and their public views. All right. So even though an employee is entitled to personal opinions, we want to make sure that we have discussions with our employees about opportunity to express those personal positions in an atmosphere where the public's not confused about whether the county endorses a particular position. All right. We want a clear separation between personal life and professional life. I know it's very easy for me to say that, and I know it's very difficult for county HR and for county employees and for county officials to craft policy and implement that policy in an even-handed manner. And a lot of it is going to be case by case where different situations arise. I think that as we've seen society progress in terms of technological advances, it becomes very easy for people to express themselves in a variety of different media and formats. Social media really wasn't that prevalent 10 years ago. Now it's everywhere. And so we have people posting on X or Facebook or Instagram or whatever platform particular employees or officials use. We have to be very careful about what we as officials or employees do when we're posting to make sure that we don't blur the lines between our public life and our private life. And likewise, as counties, when we are regulating conduct on social media, we want to be very sure that we're regulating the official business of the county and not regulating an employee's personal life. Again, easy for me to say, very difficult to implement. All of this is to say to work closely with Corporation Counsel in the crafting of these rules and the implementation of these rules. So now we're at 12:48, so we've got about 10 minutes left in this discussion, and it's open to questions and answers. And so I'll pause here. I don't see any open questions in the Q&A. Trent from Wood County Clerk has said, I think the prohibition, as it relates to electioneering, I think the prohibition on electioneering would extend to in-person absentee voting at the clerk's office and not just the polling place on election day. What say you? I agree with you, Trent. Any place that is a designated polling place where voting is occurring and the other conditions in statute are met, that electioneering would be prohibited. So I agree with you. So with that, let me pause and see if we don't have any other questions in Q&A or chat. Sarah, do you have any questions or comments? Anything that you've heard out there dealing with these types of issues? I know it's very complicated and tough to get through. Today's discussion is meant to be a start to get your mind thinking about some of these concerns. But I have had a lot of counties asking me about what they can do to regulate speech and expression, especially at county board and committee meetings. And all I can say is tread carefully, work with Corporation Counsel, but it's always a good idea to have these rules in your board rules or in ordinance where it's out there so the public has an understanding what those rules are so that we establish expectations for public comment. Nobody's surprised. Anything else that you might have heard?
Now, the question I have for you, Andy, while we're waiting for folks to enter their questions or comments in either the chat or the Q&A, is I know you are working on a set of model county board rules. Will you have something included in that will assist with ensuring that we have proper language included in county board rules for counties to take a look at to copy from? Will you have something specific, or will it be more so a you should have something included in the rules related to this?
What a loaded question, Sarah. That's asking a question where you know the answer. You know that we're going to have suggested language within those board rules that deals with these topics. And that suggested language is not going to be cut and paste template. That suggested language is going to be, hey, here's a set of considerations that you might want to think about in terms of what your board rules can look like in dealing with public comment and dealing with board member conduct and decorum. So we will put that in those template board rules. And it's been your mission and my mission for the past year, I think, to have all counties dust off their board rules and take a look and say, what can we do to make sure that we have an efficient and effective environment in which to conduct county business? And so getting those template board rules out, and I think I opened my mouth and promised that we would have some of those available by the time of conference in 3 weeks. So assuming we keep to our self-imposed timeline, I hope that all counties have something that they can take a look at and start considering here in the next month.
All right, Andy, and I see Joe has a question. He's going to save us from this banter.
So essentially, Joe is asking when I'm talking about preparation of neutral campaign materials, am I referring to employees within the clerk's office? Yes, absolutely. That's what I'm referring to, is that if we have official business of the county that somehow impacts a campaign or election issue, that we have the ability as a county to assist in the preparation of materials that are informative and viewpoint neutral as it relates to that particular election or campaign issue. But we do not have the ability as a county to direct our staff or undertake on our own in any sort of partisan or issue specific advocating one way or another on a particular candidate or an issue. So I want to make that clear. Thank you, Joe, for that. This comes up in the clerk's office. The only other exception I could see, and this happens rarely in counties, but it does happen, where we will have a referendum on the ballot, whether it's an advisory referendum on excuse me, not an advisory referendum, but a referendum on a particular ordinance or resolution that is contingent upon adoption of the referendum. Or if we have a referendum, for example, on the ballot to exceed our levy limits, we cannot, as a county, dedicate county resources to, for example, advocate for the adoption of that particular referendum. In other words, we can't have our clerk's office print up a bunch of buttons that say, vote yes on the referendum on November 5th. We can't do that, all right? But if somebody comes in and says, hey, what is this question about exceeding levy limits that's on the referendum ballot this November? What does that look like? If we have materials that explain what that referendum is, we can certainly distribute. They're viewpoint neutral. They're not advocating a yes or a no vote. They're simply explaining what's going on. So we can do that. All right, so we have a question from William. A campaign bumper sticker on an elector's car parked outside the polling location is acceptable. Would it also be acceptable for the car to participate in curbside or drive-through voting during early voting, since the polling location is now the drive-through parking lot? That's a bit of a loaded and complicated question, William. I don't think that that bumper sticker would absolutely be prohibited if the car is just simply driving through that location. But as soon as somebody parks that car right next to the drive-through location and shines a spotlight on that bumper sticker, and somebody outside that car pointing at that bumper sticker, then I think that person might be engaged in electioneering that would be prohibited at that particular location while voting is going on. So I think it depends upon the circumstances. And again, a lot of this, and you're going to get tired of hearing the standard lawyer answer out of me, which is it depends. It really does depend. These are tough issues. And I think application of these electioneering prohibitions, application of the First Amendment considerations that I've talked about earlier, that can be very difficult. And all that tells me is that you have a conversation with your corporation counsel, hopefully in advance, to avoid some of these issues.
While we're waiting for some additional questions to come in, Andy, do you want to talk about some of the programs that you will be speaking at our annual conference this year? I know there's some that may relate to this, including unruly supervisors,
Yeah, we're dealing with
all that.
unruly supervisors. How do we deal with that? Because that issue, uh, unfortunately has become more and more prevalent, at least based on what I've seen in recent years. And I think a lot of that has to do with the creep of partisan politics in a county government, which is by definition in its nature nonpartisan. I'll get off my soapbox for a moment and just tell you that, yes, we're going to deal with the whole board supervisor misconduct question at conference. We're also going to deal with constitutional officers, and we're going to talk about them. And we're going to have a really good session on parliamentary procedure. That session on parliamentary procedure is going to be 3 hours. The first hour is dedicated to foundational understanding of parliamentary rules of procedure. And then the second 2 hours is going to be a mock meeting that has scripted opportunity for common questions and issues to arise. One of the things that's going to happen is that we're going to talk about decorum at that mock meeting. There may be public commenters at that meeting, and there may be public commenters who don't stick to the agenda script that we have for that mock meeting. I'm just putting it out there hypothetically. I don't know for sure that that's going to happen, but maybe that might happen. That's an opportunity to have a discussion at conference about how we deal with those particular situations. And as a great segue, Kurt Gibbs just asked, Chair of Marathon County, which Kurt is the chair of Marathon County, which is not only the largest county board in the state, but also has an even number of supervisors. So it's the biggest and also has the possibility of tie votes. And so that's the wonderful thing about Marathon County's board. But Kurt asked, can you have someone removed from the boardroom, including a supervisor? Yes, you can. And we have a law on the books that allows you to do that. It's called disorderly conduct. And so if we have somebody engaging in conduct that is considered disorderly conduct under state statute, we can ask a sheriff's deputy to remove that person from the meeting and have them cited for disorderly conduct. Robert's rules also speaks to the concept of removal, but ultimately the question of whether we have the physical capability of picking somebody up and removing them from the meeting, I would have a tough time doing that without law enforcement involved. Anything you
Uh,
want to plug for conference, Sarah?
I don't think so. I was hoping for the plug on the Parley Pro 3 hour session. I have to tell you, it will be a fun time, a great time. You will enjoy it, but not only will you enjoy it, you will learn a lot. We did a shorter segment of this at the County Board Chairs Forum earlier this year, and I think it was very well received. I even learned something there. And so I think I highly recommend if folks have the interest, I highly recommend attending that particular session. Andy, while we're waiting, and I think we're going to probably be wrapping this up in just a moment. I just want to remind folks there will not be an In the Boardroom in September. We will be spending all of our time preparing for all of these discussions that we are going to be having at the annual conference. So there will not be an In the Boardroom in September. The next one will be on October 23rd. Andy, I don't know, do we have a topic yet for October?
We don't. And typically, Sarah, probably a month, 45 days beforehand, you and I talk about what we're hearing out there in county government world in Wisconsin and say, this is a topic that I think would be really good. And so we'll have that discussion, I would assume, in the next couple of weeks. But in the meantime, I would encourage everybody who's on this, if you have topics that you would like to see us address, email me, email Sarah, and we'll make sure that we get that into the lineup. And now we're going on. Gosh, we've been doing this for 18 months. So we probably have 16 to 18 different topics that we've addressed over the course of time. And so I think it'd be a good opportunity if counties have particular issues that we haven't addressed, let us know so that we can make sure that we address it. The whole purpose of this is to provide a deeper dive into some of these issues and hopefully give you a greater understanding of some of the concepts that we deal with. So feel free to let us know.
Yep, absolutely. If you have issues you want to address, you can reach out to Andy. You can reach out to me at WCA. Either one will work. Otherwise, Andy, I think we're about at the time in which to wrap this up. So again, just as a reminder for those that are still on, the PowerPoint slides as well as our recording of today's session will be on the WCA website under I believe events, or you can just click on the link on the upper right hand page or upper right hand side of our homepage on the website, and that'll take you right to this. The other thing I will mention is it's not just today's In the Boardroom that you will find on that particular website, but you will find all of the presentations from the WCA annual conference past, and that's where the ones for this upcoming conference will be posted, as well as all 18 of the In the Boardrooms that we have hosted thus far. So again, thank you so much for joining us today. We will see you back here on October 23rd.
Thank you all.